Welcome to Breakpoint this week. I'm John Stonestreet. We're going to start our program here right off the bat talking about what I think is a pretty monumental Supreme Court decision, at least for this term. But I think in light of the cultural moment we've been in the last several years, we could argue, just as we come up on the 10th anniversary of the Obergefell v. Hodges decision, that a lot of this traces back to that. But a very important decision by the Supreme Court about a Tennessee law that banned the so-called medical treatment for gender dysphoria for minors. So basically banning puberty blockers, banning cross-sex hormones, and banning surgical intervention. And I wanted to talk about the ins and outs of the case and the ins and outs of the decision. Really some fascinating concurring opinions and dissents written, as well as the majority opinion by Chief Justice John Roberts. And really thrilled to invite my good friend and an attorney for the Colson Center, Ian Speir, founder of Covenant Law and chief counsel there. Ian, thanks so much for joining us on Breakpoint this week.
Great to be with you, John.
All right, so let's start here first. There's a little bit of a legal technicality side to this case in terms of the scope of what Justice Roberts decided upon. So talk about, just give us an overview of what this case was really all about.
Yeah, so Scrimeti is a case that arises out of Tennessee. It involves a Tennessee law that's referred to as SB 1. The full title is Prohibition on Medical Procedures Performed on Minors Related to Sexual Identity. And as you pointed out, this is a law. There are about 24 states now that have enacted similar laws banning mutilating surgeries and puberty blockers and hormones, specifically as applied to children, minors, for the purpose of treating gender dysphoria or some kind of perceived inconsistency between gender identity and biological sex. And so this law was challenged by as the court described it, 3 transgender children and their parents, as well as a doctor. At some point, the United States, under the Biden administration, intervened, but then kind of withdrew its participation in the case. Made its way up to the U.S. Supreme Court, and the U.S. Supreme Court upheld Tennessee's law, which again bans these treatments on minors. And so, yeah, we can talk through some of the particulars of the decision, but I mean, I think the top line point for listeners and viewers is that this is a win for kids. Mm-hmm. It's a win for the protection of children against radical gender experimentation.
It is a win, and it's not a small win. But just also to be clear, despite what the headline said yesterday, and I'm saying this, we're recording this on Thursday, this came out on Wednesday, despite what the headline said, this is not a ban on the gender treatment for minors across the United States. This is merely upholding states' rights, essentially. A state has a right based on the legislature's best analysis of where the medicine and science is at the time to enact these bans and enact these protections. So that in and of itself is a win.
Yeah, absolutely. I mean, it affirms the power of states to protect minors from this kind of harm. And importantly, it refuses to constitutionalize a right to sex-rejecting medical treatments and really pumps the brakes on the aggressive trans movement, at least as it relates to kids.
So Justice Roberts basically ruled that this wasn't a law that required kind of the additional scrutiny. And this was about kind of the level of scrutiny that various levels of legal discrimination, and we think of discrimination as a bad word, but essentially like the law has to discriminate. And so there is this kind of tradition from the Supreme Court, or this ruling from the Supreme Court, a standing in which certain cases involving certain things require heightened scrutiny. Mm-hmm. And Justice Roberts said this does not. Walk us through what that means.
Yeah, right. So this was brought as an equal protection case, and the plaintiffs or the challengers to the Tennessee law claimed or alleged that this law classified based on sex and transgender status. And it's well established that if the law does indeed classify or discriminate on the basis of sex, then it is subject to some form of heightened scrutiny under the Equal Protection Clause. The courts have not resolved whether a law that discriminates on the basis of transgender status is subject to heightened review. But the other thing to know is that laws that don't classify on an impermissible basis, that don't classify based on sex or race, are subject to what's called rational basis review, which is the most kind of deferential to policymakers and to legislatures. And so the court ultimately concludes, Chief Justice Roberts for the court ultimately says, this is a law that that does not classify on the basis of sex, that the relevant classifications here are based on age, namely minors, and medical use of particular treatments, the purpose for which these treatments are being used or prescribed. And Chief Justice Roberts says, and the court agrees 6-3, that that's not a sex-based classification. That's an age and medical use-based classification. That's subject only to rational basis review. And the court ultimately says the state can, under that level of review, the state can, take sides in a frankly, what's still a kind of medical debate. There is not, despite the dissenters and the plaintiffs' attempts to portray it this way, there is not a medical consensus around the risks and benefits of these treatments, particularly for minors. And in fact, John, as you know, and as you have covered on this program and elsewhere, the direction of travel for the studies now is that these treatments are indeed harmful. In some cases, they result in irreversible damage to these children, infertility, regret. We have a whole detransitioner movement that has begun to surface. And so what the Supreme Court says is Tennessee and other states can take a look at the state of the evidence. They can take a look at the direction of travel of the studies and say, we think this is harmful to kids, and we're gonna ban it, or we're at least going to restrict it and limit it in certain ways. And the court says that's rational. States can indeed do that.
Yeah, I mean, that was, I think, really important to really admit up front, too, on the medical discrimination part of things, right? Because these are medicines. For example, if you have a child is dealing with early onset puberty, right, which is harmful, these certain puberty blockers, are a legitimate treatment. Someone is hitting puberty way, way too early. But using it for a mental issue of mental distress, that's not physical harm at all. That's off-label use, right? And to basically say, well, because we want to use this medicine this way, even though it's in a completely different sort of a source, is just completely, that doesn't qualify as sex discrimination. So making that distinction, even though it's a bit of a technicality that Roberts is ruling on here, that's actually a really important distinction to make, I think, isn't it?
Yeah, that's right. I mean, and he points out that using it for early on, using these like hormones or blockers for early onset puberty is different because those treatments actually end when the child hits the normal puberty age, whereas these off-label treatments to treat gender dysphoria, in some cases they're used to block what's a normal kind of human process of development, which is puberty for these kids. And when you do it at that stage and you keep it in place during that stage, that's what actually results in the harm, and actually in some cases permanent harm.
Permanent infertility, and other things.
Right.
So the very thought that this could be considered sex discrimination, the attorneys here for the children were really arguing that comes out of Bostock, right? I mean, that the Bostock decision, which was decided a few years ago, having to do with employment discrimination, Justice Gorsuch writes that opinion, makes this really strange claim that it's not really sex discrimination, but it is sex discrimination because it's sex discrimination. That was my understanding of he's talking about employment law. It's different, but that they were really relying on that. And both Roberts, certainly, I think Justice Thomas and Justice Barrett all said, no, it just doesn't apply here.
Yeah, that's right. I mean, what you see is a court that is reluctant to apply Bostock outside of the Title VII employment context. And so we've got numerous decisions now, both from the lower courts and now from the Supreme Court, saying, seeking to limit Bostock essentially to its facts and to its legal context, and saying, at least for purposes of equal protection cases like this one, Skermeti, we're not going to apply the logic of Bostock. And, that logic is sort of highly technical, and the distinction that Chief Justice Roberts draws here in Skermeti is also a kind of it's a very technical distinction, and you have to sort of get into the strange logic of Bostock. But the basic point that Chief Justice Roberts makes is, at least in the employment context, an employer's decision about say terminating a man who is attracted to men versus not terminating a woman who's attracted to men, the only relevant, the only thing that you change in those scenarios is the sex of the person, and that changes the employer's decision making, and so that's sex discrimination in the Title VII context. And Chief Justice Roberts here in Schermetti says that's not quite the way this works, because we're talking about not only a distinction based on age, because this applies only to children. We're talking about a distinction that turns on the purpose of the medical treatment. And there are permissible uses of these and impermissible uses. And the impermissibility doesn't turn on the sex of the child, it turns on the purpose for which that treatment is being used. So it's just a different logic than Bostock. But
I think it's important. And the reason I think it's important is I've said this for a long time, is that when it comes to the sexual revolution, we treat issues of sexuality as if they play by a completely different set of rules, right? Things we would never allow. I mean, this goes to the heart of the trans issue anyway, right? Body dysmorphia in some form, when the mind and the body doesn't align. We don't treat any other dysmorphia, and there's a lot of them, right? Most notably eating disorders. We don't say, oh, you know what we need to do? We need to align the body with the mind. In other words, even though this girl is crazy skinny and is desperately and dangerously not eating enough, we're going to believe her mind that says she's overweight, and we're going to continue to align. We would never do that. It would be insane. It's only in this category. And I thought that was the logic in the Bostock decision, where, suddenly you have this kind of category that doesn't apply, and it plays by its own rules. And it seemed like Roberts was saying, no, not this time. It's not playing by these rules this time.
Yeah, I mean, and I think that point, John, really ties into some of the worldview implications of a decision like this. Schermetti isn't doing Christian worldview. Obviously, Chief Justice Roberts is not doing Christian worldview, but this decision is consistent with the idea that biological sex is an embodied reality. It's part of the truth of who we are. It's part of the created order. And thanks to this decision, now states can align their laws and their policies with that truth, with that reality.
Yeah, that is good news. I want to talk quickly about the concurring opinion from Justice Thomas, and you might want to mention Alito too. It seemed to me that even though Roberts' majority opinion was limited, as Thomas tends to do, he went further, and he went into some weeds, both in terms of, look, all this was created by these so-called experts, and we've got to stop listening to the so-called experts. That was a smackdown essentially of a lot of people, but especially WPATH. And then he mentions WPATH, the World Professional Association of Transgender Health People. And basically, I think that's what that stands for. But it just basically a bunch of self-proclaimed experts that made a bunch of stuff up and referred to each other as authorities and created a lot of this mess. You have him going to puberty blockers and cross-sex hormones and surgery, and talking about their long-term potential and permanent harms that they can do. I mean, he went into Bostock, and it sounded to me like he was like, hey, Bostock created a lot of these problems, and we're going to have to come back. It seemed like he was daring people, to come and, hey, let's challenge this. Did you have that same read of Thomas and maybe Alito?
Yeah, I mean, Thomas's concurrence is, everybody should go read it. It is a kind of devastating takedown of the so-called medical consensus around this issue. I mean, he uses that term "so-called experts" several times throughout his concurrence.
And scare quotes.
That's right. And he has some great lines in there, and some great discussion of the state of the medical evidence. He says, for example, there's no medical consensus on how best to treat gender dysphoria in children. He points out that kids can't consent to this kind of medical treatment, that even scientists don't fully understand the implications yet. And, how much more so is that true of kids who don't fully understand the implications for their own fertility and their own kind of long-term identity and sexual health. He also points out, this term gender-affirming care. So a lot of the headlines about Schermetti after this decision were, in blow to gender-affirming care or something like that. Or Tennessee's ban on gender-affirming care is upheld. And Justice Thomas points out that it's not even a good or accurate term. A better term is, I've heard the term gender transition services is how sometimes these are described, but I think the better term is the sex rejecting medical treatments. I mean, that's really what these are, is medical treatments that reject one's biological sex. But then on the WPATH point, he really goes after and just takes down WPATH. Now, some of that's enabled by the fact that there was a release of a lot of the kind of internal discussions and documents from WPATH, called WPATH files. If you Google that term, you'll come across that. And so he uses some of that to point out that a lot of their guidelines and their standards really are driven by politics and ideology and a desire to get these kinds of laws struck down or these kinds of medical treatments upheld. And he points out that this, they're not really doing science. They're doing a lot of ideology here.
Well, listen, it was notable that when this case started and when this case now concludes, an awful lot has happened, right? I mean, we've had the whistleblowers, we've had the closing of gender-affirming or these so-called gender-affirming care clinics. We've had additional medicine. And I was really struck, just quickly, I know we're trying to cover a lot of ground in a short amount of time, but Justice Sotomayor's dissent just made claims that would have been easily made and were often made when this case started. It was almost like she heard the oral arguments or read it before the oral arguments and wrote her dissent way back when, and then ignored everything that came out. Ethan Heim is an ADF client who was one of the first whistleblowers on this and got in a lot of trouble for being fired and was even fired for standing up against this. And he wrote a devastating thread on X where he kind of took over Sotomayor's claims about, the medicine and people are going to die and all that. And you're just like, none of this is supported by the facts. In fact, the data now, as you said, is headed the other direction very, very clearly. And basically, her sadness led her to dissent, she said. I mean, it was just a strange thing, but it does seem like there's a lot of progressive elites that aren't keeping up with where the science actually has gone on this.
Yeah, that's an interesting comment about Justice Sotomayor seeming to have written this dissent in the face of or contrary to the evidence and the reality. And Dr. Heim's post on X, you and I have both dug into that and read it. It's really good, and he points out that the views of Justice Sotomayor and her colleagues really don't just don't align with the evidence and or really with the logic and the fact that these kinds of laws seeking to protect kids just don't discriminate on the basis of sex, and it's a bit strange for Sotomayor and her colleagues to be relying on WPATH and citing him as some kind of medical experts. I mean, that ship has sailed. I mean, their credibility has been deeply undermined, let's say.
Yeah.
And she does. Sotomayor has this line about in sadness, I dissent. I can't say I've ever seen a justice at the Supreme Court say that they're dissenting in sadness, but that was her line. I think it's also interesting to point out that the 6 justices in the majority, plus Justice Jackson, who joined Sotomayor's dissent, all of them actually have children. 2 out of the 3 dissenters, Justice Sotomayor and Justice Kagan, don't. And I don't know whether that plays a role here, but like if you have kids. The polls show parents across the country are concerned about the direction of these kinds of medical treatments, and Dr. Heim has been doing really wonderful work and being the whistleblower, suffering significant personal consequences, blowing the whistle on Texas Children's Hospital and what they were up to down there. So he's one to follow in this debate for sure.
Absolutely. I've met him. He's a bright dude. Let's just put it that way. And he is a force of nature. Last question. In the scheme of things, both in terms of where we've been, where we're headed, in light of something like Obergefell being a 10th anniversary, that we're coming up on the 10th anniversary, we got Bostock and so on. What's the significance of this decision?
Yeah, well, I actually I think the primary significance is going to be in the realm of the sort of the transgender movement and the transgender debate. I don't know whether there's any spillover between that and Obergefell and the debate around same-sex marriage. I think those two are happening in parallel, but Skermeti really pumps the brakes, I think, on the trans movement. I mean, the New York Times today had a piece about how big of a loss this was for the trans movement in particular. And, I think we should celebrate that, because this is a movement that, at least with respect to children and as well as adults, really has been uniquely harmful. It's gratifying to see that states like Tennessee and many others can step up and say, we are going to ensure that medical standards for kids are grounded in science and evidence, are not harmful. And I think that gives parents comfort too, knowing that, particularly in places like this, that they're not going to be sort of emotionally blackmailed into thinking that they have to go along with some of these treatments when they're children, when they do have, there are kids who experience gender dysphoria, and knowing that rather than trying to change the body to align with one's mind, that what we should be doing is helping children and people, adults, also become comfortable with their God-given sex, because that's a gift, and it's something that's beautiful about what God has given us.
Yeah, Ian Speir, attorney for the Colson Center and founder of Covenant Law, and grateful for your contribution here on Breakpoint this week.
Thank you, John.